one thing that I would want to ask you, that there have been developments in Section 50, that courts have made some observations on Section 50 of the Prevention of Money Laundering Act, whereas there are some other developments also. Could you also further reflect on those 3-4 developments in your next
So
answer?
let me give you 3-4 more examples, because as I said, this has been little telescoped in the last, let's say, 18 months odd. So they're all coming thick and fast now. The next and possibly the most important is the judgment which we obtained in Manish Sisodia a few weeks ago. It's a very important judgment by the bench of Justice Kawai and Vishwanathan, where they have laid down a number of principles. They have looked at length of incarceration. But above all, the most important component of this judgment is, in one line, constitutional safeguards of 2021 and 22 find inordinate delay in trial anathema. And if there is inordinate delay in trial, then these constitutional safeguards of 2021 and 22 will trump and override 45. It's a new facet. 45 doesn't talk of delay. 45 is a special bar. It can't be easily given bail to you. The sections don't specifically deal with delay. Normal bail jurisprudence is supposedly defeated by the bar of 45. Judges said no. The Constitution, which ensures a quick trial, a not inordinately delayed trial, and says you have a presumption of innocence till you are convicted, is a higher document than 45. So that's why I use this felicitous phrase, it trumps 45, where you are, of course, genuinely able to show delay. In Sisodia, we got a thumping judgment because we were able to show inordinate delay. Now remember, when you argue such cases, be careful. You cannot say that, look, the trial is inordinately delayed, but here is a list by which I have contributed to the delay. And notwithstanding that Nangia has contributed to the delay, he must be released despite his own contribution. That's not the way it works. You have to show, and we showed, for example, an objection was raised by the prosecutor that, look, there are 14 applications by Mr. Singhvi. That is by my client, Sisodia. And that contributes to delay is not my fault. We gave a chart to the court, and it was very interesting and laughable. All 14 were allowed. 12 of the 14 were for silly small things which the prosecution was opposing. So the court said, look, if I have to exercise my legal rights, for example, you don't give me documents. There is a provision 207. Without 207, you can't really prosecute because the poor defense guy has no documents. So you don't give it. I ask you a second time, you don't give it. So I have to file an application. The court grants it. So the court said, the Supreme Court said in Sisodia that where the trial court has allowed all of Mr. Singhvi's 14 applications, how can he be said to be guilty of contributory negligence in delay? So this is the way a very important principle is. And then also, another misconception the Manish Sisodia case dislodged and punctured, that this principle, bail is the rule, jail is the exception, will not apply where there's a special provision like 45. Because 45 is the whole issue. And unfortunately, 45 was taken up on a pedestal by Vijay Madan Lal Chaudhary. So they said, no, bail is a rule and jail is an exception, is also applicable to PMLA. And they said, why? And they put a very nice phrase. I must commend that order. It says, bail is a rule, jail is an exception, is nothing but a paraphrasing of the liberty concept of Article 21. And again, the Constitution is above your statute, above 45. Then, of course, there is the other judgment which happened